I'm Jeff Belomo with Belomo and Associates, and welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. And in this episode of the Red Wagon Estate Planning and Elder Law Show, we are going to be talking squarely about estate planning and elder law, as we will be talking about what you should do immediately following a divorce regarding your estate planning, as well as what type of planning you may need or consider if you're getting married after a previous relationship. So if you're in a second marriage relationship, what you should consider, and especially if there are blended families where each of you have kids to a prior relationship. Before we get into the meat and potatoes of the show today, I do want to do the disclaimer. Remember, please do not take what you hear from this show or any other radio show to constitute legal advice. This show and any other show should be for informational, educational, and entertainment purposes only. Once you meet with an attorney licensed in the state that you reside in, who specializes or practices in the area that you are looking for advice in, and once they know the facts, then and only then should that be taken as legal advice pertaining to your specific situation. Now today we're going to talk a lot about what happens after a divorce in an estate planning context, and then what happens if you're considering remarriage, and as well as blended families and what should be considered there as well. At Belomo and Associates, we provide free educational workshops so that what happened to the Belomo family doesn't happen to yours. Our free workshops are offered in the York and Lancaster office on a regular basis, pretty much every week, in the estate planning or pre-planning context, the crisis or Medicaid planning context, as well as special needs planning, life care planning, and administration after the loss of a loved one, whether it be because they have a will and they have to go through probate, or a trust and they are going through trust administration. All of those workshops are free, and after you have attended the workshop, in the workshop they will describe the process to move forward, and that way you don't have any money that you have outlaid without knowing up front what the pros and the cons and what it would look like and what the costs associated would be. All right, so now, first things first. Immediately following a divorce, I think that the first thing that you probably want to do is to have your estate planning documents redrafted and also changing all beneficiary designations. So in the example that I'm talking about right now, imagine that you're married and the divorce just goes through and now it is final. Probably all of your documents will still provide for your ex-spouse, presumably as the financial power, the medical power, the executor in your will, as well as probably the primary beneficiary. Now, some of you might be thinking, gee, Jeff, I heard once that there's a statute that says that if the divorce is final, look, here's what I'm going to tell you. My advice to you is the divorce is final, get your documents redrafted. I was in a room of about 100 professionals, and we were looking at the statute, we were interpreting the statute, we were arguing over it. What does this mean? What does that mean? And ultimately, my conclusion from the front of the room was, look, if a client comes into your office as a professional and they are looking for advice, get everything redone. Get everything done so that the ex is not named in the documents and that you're not relying on something that the bank or someone else may not even know exists, and he or she may be able to still act until they realize it. Let's not take chances. Let's just get everything redone. So that would be those documents such as the financial power, the medical power, the last will and testament. If you have a trust, you probably have your spouse as the trustee. If you can change that, you'll want to change that. And also beneficiary designations. You'll want to change your spouse from being listed on the beneficiary designations so that they're not still named. So that could be life insurance, that could be 401k, IRA, that could be annuities, that could be all kinds of a host of things. Maybe you have them listed on a transfer on death account, a payable on death account, an in trust for account. So you'll want to take an inventory of everything that you have and make sure that they are not named in those documents. If you're looking to take action before the divorce is final, I would definitely touch base with your family law attorney who is assisting you with a divorce and making sure that everything is copacetic with what they're doing through the divorce proceedings, and that you're not violating any agreements or anything that's occurring there. So definitely get legal counsel from your family law attorney, and absolutely you should be redoing all of your documents to get rid of the ex-spouse and naming new people. That also will probably a good opportunity now to consider who a backup would be. Originally, you were probably counting on the spouse and then maybe someone else. Now someone else is probably first, so you're probably going to want to think about who the second person would be now in that instance that you don't have the spouse anymore. So definitely a nice just start of the show today, which is if you're getting divorced, make sure you're updating all of your documents from the estate planning perspective, the beneficiary designations, the life insurance, the retirement accounts, and all that stuff, so that everything is looked at and that you have eyes on it and that everything is updated. Reach out to your financial planners, your insurance agents, any professionals that you're working with, letting them know that you're going through that process, and they will make sure that they guide you on what needs to be changed. All right, now, the next thing I want to talk about is, okay, Jeff, the divorce occurred. I changed all of the documents. I changed all the beneficiary designations. Now I'm considering getting remarried. What considerations should I take now based upon the fact that I'm thinking about getting remarried? All right, so first and foremost, I would definitely talk to a family law attorney or someone who does prenuptial agreements to understand sort of the rights and responsibilities of being married, and once you are married, what that means from the family law context as far as what they would be entitled to. I am not a family law attorney. I don't play one on TV. I don't pretend to be one. So you'll definitely want to make sure that you are getting that legal advice. And to the extent that you are getting a prenuptial agreement, the family law attorney will be guiding you through that process. The probability is that in that agreement, you're probably both going to be agreeing to waive the elective share right. So if there is a prenup, presumably that will be part of it. And what that means is, by law, once you are married, the spouse has a right to elect against the estate and will receive an elective share right. So let's call it a third of the estate of the spouse. All right, so that is by law, the fact that you're married, you are entitled to it. Now, this becomes extremely important in a second marriage situation, particularly when you have prior children and you're looking to provide for your children and not your current spouse. You will want to make sure that that is spelled out black and white in the prenuptial agreement so that there's no issues later, so that the spouse doesn't elect against the will. Now, it would require them to take affirmative steps. It would require them to actually file the elective share right, which probably means that they'll have to work with an attorney or someone to assist them with that process. But certainly, they absolutely can, and in a lot of cases they do. And so if it's important that that situation not occur and that you don't have to take a chance on them doing it, make sure that that is addressed up front and that there is a prenuptial agreement that waives the elective share right. So typically in the context that we're talking about, a prenuptial agreement would say what's mine is mine, what's yours is yours, and we can agree to have joint assets together, but if it's something we brought into it, we're going to agree that neither of us are going to touch each other's and it's going to go to the kids. We're going to waive the elective share right. So it's going to set forth all of that in black and white so that there's no misunderstanding or fighting later, particularly after you pass, so that your kids aren't fighting with a spouse who is filing an elective share right and he or she would be entitled to it, which particularly if there's a prenup agreement, probably wasn't what was intended. Now, the one major consideration as it relates to elder law is that the state of Pennsylvania is not a party to your prenuptial agreement. So we see a lot of cases with older individuals wanting to get remarried, and they come in and ask for advice in regards to, the second, third marriage situation. Sometimes, one spouse may have a lot of assets and the other spouse maybe not quite as much. So let's just say, for example, that the new wife has a lot of money and the husband does not, and they're getting ready to get married. Maybe they're in their 80s. Maybe one of them or both of them, are having health issues, or just by their age, they're needing some assistance. In that context, where there's two people who have a very different, financial situation, oftentimes people really have to consider whether to get remarried. In the long-term care context, when we're looking to look at protecting assets, or we're looking to qualify somebody for Medicaid or medical assistance, the government looks at the assets of both people. So whether it's in her name, his name, joint names, it counts as a resource. There are a few exemptions, such as a house, a car, the community spouse's retirement account. But again, you don't know who the community spouse is going to be, because you don't know necessarily which one is going to need care first. So you can't really predict that. But outside of those statutory sort of, okay, we'll exempt the house, the car, and the community spouse retirement account, everything else gets put in a pot. So in the scenario where the husband needs the care, who does not have a lot of assets, the assets of the wife are at risk. They are part of the pot. They are part of, you could only keep half, but no more than, $150 some thousand. That is her assets as well that figure into that calculation, which means her assets are at risk. So in that second marriage context, you really want to be careful. Now, if you both have similar assets, you both have similar wherewithal, and both of you kind of go into it knowing that you're willing to put at risk those assets, fine. If you also know that, you work with an elder law firm, and you know that there's crisis rules that would potentially be able to protect assets, and you're okay relying on that, okay, fine. But let's just remember that the crisis rules for a spouse allow us to protect assets for a spouse, but not for a child to the extent that we can protect for a spouse. So in that context, now we are basically directing the money to the new spouse away from the children from the first relationship. And yeah, you could probably do some things where that spouse agrees to provide, but it is not a guarantee. It's very hard to enforce that. It's certainly a risk, and definitely not something that you want to go into lightly. Again, once you are given advice, once you know the pros and the cons, you can make a decision that is right for you and your family. But making sure that you understand the risks associated are extremely important. So in this context, just make sure that you understand that a prenup is not going to bind the state of Pennsylvania. And as part of the Medicaid rules in the state of Pennsylvania, the assets of both husband and wife are part of the pot. If they're not exempt, they are part of the pot, which means if the wife has more assets coming into the second or third marriage, her assets would be at risk if the spouse needed care. And currently, we're looking at about $14,000 to $15,000 a month for long-term care. The average in Pennsylvania is currently $14,676. So we're not talking about an insignificant amount of money. And particularly in cases where there are children to a prior relationship, and maybe you wanted the money to go to your kids. Well, the only way to protect 100% is if it goes to the spouse, which would certainly fly in the face of that. So we definitely want to plan for that. We definitely want to understand the risks associated with it. And you would definitely want to talk to a professional providing specifics of your case to an attorney licensed in the state that you reside in to get advice specifically on that topic. But for the purpose of this podcast, suffice it to say, just want you to be aware that in a second marriage situation, there is an elective share right so that the spouse would be entitled to a third unless that was waived in a prenuptial agreement. And also, to the extent that you're getting married later in life, be aware that getting married means that both assets of both spouses will be at risk if the other spouse needed long-term care. So if you want to learn, the Medicaid crisis rules, there's plenty of podcasts on that. We have free workshops on it as well. For the purpose of this video, I think it's suffice it to say that the assets are at risk if you get remarried. A prenup won't bind the state of Pennsylvania, so you'll want to make sure that you're at least aware of that and planning for it. All right, so now let's take the show and let's talk a little bit about, all right, Jeff, I am divorced. I did make all those considerations about the elective share right and about all of that stuff. But now I'm getting ready to do my planning. Now I want to get it redone. I'm remarried or getting remarried. So each document, I think you'll want to look at kind of separate, right? So you want to consider the financial power, the medical power, the last will and testament, who would be your executor, where would the assets go? When you're looking at trusts, who would the trustee be? Who would the successor trustee be? I think each of those have a different sort of discussion. When you're dealing with medical decisions, of course, now you have to decide, do I want my current spouse or do I want my children to make medical decisions for me if I can't make them for myself? I think this is a case-by-case scenario. I don't think that there's a one-size-fits-all answer to this. I've seen a lot of different people have very strong opinions on varying, kind of ways that they approach this. Some feel for medical, I want it to be my spouse. That's who I'm married to now. Some say I want it to be the kids. Some say I want it to be both. If you're naming both and you're saying that they have to agree, you need to understand that, inherent in that means that they have to agree. And so if you are putting your spouse and your children in a situation where maybe they don't get along or they don't see eye to eye, that could be something to consider. Also, if you're picking one and not the other, there's certainly a fine line there of some hurt feelings and some, potentially tough conversations. But at the end of the day, they have to be had, and it is your decision. I think a lot of people feel differently about medical decisions versus sometimes financial decisions. Again, I think that the answer to who your financial power would be very case by case. It will probably depend on whether all of the assets are joint with the new spouse, whether they are not joint, and whether you each have your own assets. If there's a prenup and your assets are separate, you might want to go to your kids and not to the spouse. A will, in Pennsylvania currently, it is very, very difficult to do any type of trust planning under a will anymore because a lot of institutions will not fund a testamentary trust. So therefore, most distributions in a will are outright. If you leave money outright to your spouse, he or she then owns the asset, 100% of it, and can do whatever he or she wants with the money. Meaning, if they get remarried or if they get in a new relationship, or if they just decide that they want their kids to inherit it, they can change their estate planning or provide in their estate planning for whomever they want, and your kids can be written out. So in blended family situations, we often see trust being used after death so that we can guide and direct where the money is going to go. If an asset is jointly owned with a new spouse, that is probably going to will pass automatically to that spouse if they own it with rights of survivorship. If you name a spouse as a beneficiary on the life insurance, the retirement, all of that, it will go automatically to the spouse. So this is where it's very important to understand there's a difference between probate and non-probate assets. Non-probate assets transfer by operation of law immediately upon the passing. So if you name a new spouse as the beneficiary, it transfers to them. If you own an asset joint with them with rights of survivorship, it transfers to them. It doesn't matter what your will says. It doesn't matter what your trust says. If they're owned jointly or you have the beneficiary designate them on them because they're in your name, that's how they will transfer. So if you're in a second marriage situation with blended families, you're probably going to want to really consider how do you want the asset to transfer. In a lot of cases, if I want the spouse to have use of the money or the assets during life, we will put the money in trust for the spouse, maybe with one of my children as the trustee of the money to ensure that my spouse is taken care of, but also then when she or he passes, the money transfers automatically to my children, and I'm not worried about the situation where I own something joint. It transfers automatically to my new spouse, and then he or she then takes it and changes the beneficiary or changes the will or changes whatever, and then gets it out of my family and leaves it to his or her family. That's where, you really need to consider how the entire estate plan comes together, the difference between probate and non-probate assets, and that they are titled according to your plan, which is why you absolutely need to work with, a professional, a legal advisor, an attorney who practices in this area so that you are completely certain that it's going to go where you want and how you want. So now that we know kind of what it means to own assets jointly, it's going to transfer to the new spouse or beneficiary designated directly to the new spouse. I did mention that we use trusts a lot of times to give access to the new spouse. Maybe you give them a certain allotment, maybe you give them access to a certain percentage or a certain amount, or you simply let it up to the trustee. Now, obviously, who the trustee is and what the relationship is going to matter, right? You're not going to want to name somebody that will never give a penny to your new spouse if your intent was to give access to the new spouse. You could use a third party professional trustee or professional that does it as a living, insured, bonded. That way, if something were to happen, you know that your family and your estate would be taken care of. And also, more likely than not, your spouse would be as well, because a third party wouldn't have the emotional ties and connections to a blended family. So that's certainly a consideration as well. There's a lot that goes into blended families, because a lot of people will say to me, look, Jeff, I want my spouse to have access. I want my spouse to use it. But when he or she is done with it, I want it to come back to my family. I don't want his or her children to take it outside of my family and then it never to come back again. Which in some cases you see families say, nope, we're going to keep it. My assets go to my family. Your assets go to your family. We're not even going to let each other use it, assuming we don't need access to it, or we're not relying on that money. To the extent that we are, trust after death are a great way to provide access to the money, use of the money, but not have it go outside of the family. And then there's the consideration of, okay, now who is going to be the person who manages the money? The trustee, the person in control. And then, of course, there's the dynamics of the family versus a professional, which I think is definitely case by case. I would definitely recommend that you work with the professional and ask these questions specifically. Tell them a little bit about your specific situation so that he or she can provide some advice that might be beneficial in the particular case that you're in, specific to your facts. Today, what I'm trying to do is talk from a very high level about the different considerations that go into it and what you might want to consider. The one comment I wanted to make about the medical power of attorney or the healthcare power of attorney or healthcare proxy, if in that document there is a living will, that is called an advanced healthcare directive. With the living will, you're going to decide if two qualified physicians put in writing that there is no realistic hope of recovery, that you will always remain vegetative, comatose, permanently unconscious. Do you want heroic and life-saving measures, or do you want them to withdraw treatment? I would recommend this particularly in a second marriage blended situation where you get to make that decision for yourself. Yes, I want heroic and life-saving measures. No, I do not want. That way it is in black and white. It is in your preference in writing, so that both the new spouse and the children from the first relationship or from a prior relationship know exactly what it is that you intended. And if it ever had to be enforced, someone could go into court and ask a judge to enforce what was black and white, which were your wishes, so that we at least have something so that we know what that was. in those contexts, it can get very hairy when you're dealing with a new spouse and kids to a prior relationship, even if there is a healthcare POA that names who the proxy is. So we want to be as clear and specific in those cases. And I think that's also a very good just general statement. I think the more detailed you are in a second marriage situation with blended families, the better. I think the more specific you are, the better. I think the more open that you are with both sides, the spouse and the children, about your intentions, about your planning, about what you're doing, probably will save a lot of headache later for the families. I've seen that kind of turn sideways in a lot of ways. And the one thing I do want to just say before I end the show today is, I think people often think when I tell my stories in workshops about, Biff the pool boy, or, that's a funny story that I give in the workshops, that they think that somehow I'm saying that you shouldn't trust the spouse. And that is not at all what I'm saying. I'm saying that in life, when you lose a spouse, most spouses that I talk to, they will say, I want my wife, I want my husband to remarry. I want them to enjoy their life. I want them to be able to enjoy the next 30, 40, 50 years. And, maybe I do want them to have access to my assets, maybe not, depending on the situation. But when they die, I want the money to go to my children. And that is the piece that I think is really important to remember. If I pass, I want Whitney to remarry. Let's make no qualms about it. And I want her, hopefully, to be able to get a property near water and enjoy it. And I hope the views are great. But when she passes, I want that property to go to my daughter. I want Deanna to be the one who inherits that. I don't want to take a chance on Whitney's married for another 30 years. She commingles her assets with her new spouse. That property gets put in joint names. And then lo and behold, she passes, it transfers to him. He then does his will, provides for his kids, and that property now is out of my estate and my daughter gets nothing. There doesn't have to be any ill will. There doesn't have to be any ill intent for that to occur. And I've seen it happen thousands of times. So I would much rather give use of the money, give use of everything. And then at her death, it will automatically transfer to my daughter. That is how a lot of people feel about it. And I think that people think it's because there's a lack of trust, and that is not the case. I just think that when you're married for 30, 40 years, it's very easy to commingle. And the money that is coming from my life insurance or from my retirement, I want to make sure ultimately gets to my daughter when my wife is done using it. So no ill will, no ill intent, just I want to be very clear, and trust after death are definitely a way to do that. So, man, we talked about a lot today. Certainly got in some weeds, some details. I had a lot of fun. I hope you did as well. I want to thank you for joining the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law and, well, hey, anything else we want to talk about. On this podcast, we talked all about what should you do and what should you get updated in the event of a divorce, from the estate planning context as well as the beneficiary designation context. If we're going to get remarried, what considerations should we have? And particularly when there are children to a prior relationship and we are going into a blended family situation, what should we consider? What should we think about? And what are some options? Thank you so much for joining us today on the Red Wagon Estate Planning and Elder Law Show. Until next time, we'll see you real soon.